Okay, this order is for an application for immediate appointment of temporary administration pursuant to Texas State Code Section 45520001. You may proceed, Counselor.
Yes, Your Honor. So this is a little bit of an unusual situation. We represent a fellow who was involved in a car wreck with Mr. Sexton. We're about to file the case because limitations is approaching. But it turns out that as we were looking to serve Mr. Sexton, we found out that Mr. Sexton has passed away. And so in order to proceed with the claim, we need to have a legal entity as a defendant. We can't just sue Mr. Sexton because he's passed away. We can't just quote sue Mr. Sexton's estate because that'll get us dismissed. And so in this situation, the Estates Code allows us to basically petition to have a disinterested party, who in this case is Mr. Snyder, who's also a lawyer, of course, be appointed just for the sole and limited purpose of accepting service, insurance company on notice, and, saying insurance company here, deal with this situation. And so we have filed what we believe are all the appropriate, documents and proofs to support that.
Okay, do you have anyone giving testimony this morning?
No, Your Honor. I mean, Wyatt, obviously, Mr. Snyder would be prepared to, I guess, state his willingness, but I don't know if Mr. Snyder wants to just extemporize, or how do you want to do that, Mr. Snyder?
All right, let's go ahead and swear him in.
Yeah.
Raise your right hand, please. Melinda, you're muted.
Do you swear or affirm that the testimony you're giving is true and correct, so help you God?
I do.
Okay, you can proceed, Counselor.
Mr. Snyder, could you please state your name for the record?
Wyatt Snyder.
And Mr. Snyder, you are an attorney in good standing with the state of Texas, is that correct?
Yes, sir.
Okay. And are you familiar with the procedure that we are going through here?
Yes, I've done it multiple times before for your firm and for other firms.
And can you just describe for the record what the nature of the proceeding is and what the purpose is?
Sure. It's my understanding that Mr. Sexton passed away, that there's no estate pending, and under the Estates Code, your client has filed an application to appoint a temporary administrator for the sole purpose of accepting service of a lawsuit and turning that service over to the insurance company, and only for that purpose. In my experience, we've done this before, and essentially once the temporary power or the authority that I'm given under the temporary order is done and completed and turned over to the insurance company, then the temporary expires. There's no assets, there's no accounting, there's nothing to really do at that time, and then the temporary expires. So it's just basically providing that one specific limited power, and that's it. And there's really nothing else to be done other than that.
And of course, if anybody were to want to open an estate or come in to replace you because they claim to be Mr. Sexton's heir or somebody who takes under Mr. Sexton's will, you understand that you would willingly step aside and would have to step aside because, again, your purpose here is very limited, correct?
Absolutely. And that's happened before too. Most of the time it doesn't happen because typically the person passes away without any assets and nobody wants to do anything. But yes, if we did have something and somebody came forward with a will or something, I would be glad to step aside. Yes.
Sure. And you understand, of course, that pursuant to your appointment, as we have requested, you would not have the power to buy or sell anything, to find any bank accounts, do anything with any bank accounts, enter into debts. I mean, nothing that would affect the financial affairs or the property, any property that Mr. Sexton may have held at the time that he passed.
That's correct. Because my understanding of the Estates Code under the temporary order, I'm only giving the authority that's in the temporary order and nothing else, and don't want the authority to do anything else.
Okay.
And I've read this. I've read the proof. I've read my affidavit, and everything that's been filed and everything, to the best of my knowledge, is true and correct to what I know.
Your Honor, I think that's all the questions I have, unless there's anything else that the court would like to ask.
I was just reading over the authority given under the temporary administration. All right, so what about a bond amount?
Well, Judge, I mean, in my experience, I would make it as minimal. I'm not going to take any assets. I'm not going to hold any money. I'm not going to conduct any business. And so I would say whatever would be a minimal bond. Basically, I'm going to get served with paperwork and turn it over. And so whatever the court would think would be an appropriate bond, or I would say minimal, whatever the court would decide.
Yeah, this is different. I don't know in how many years I've ever seen this before.
Yeah, and I may not have done it, but we do it a lot. I mean, and so
no, I can see why it's necessary.
It's necessary, and so I mean, in my experience, a bond like this, $1,000, somewhere between five. That's just my, because again, the bond is supposed to protect if I do anything wrong, and I've got such limited authority. It'd be hard to mess that up. It'd be hard to.
Oh yeah, it's definitely limited.
Yeah.
Okay, I'll approve the order appointing temporary administration. And Wyatt D. Snyder is appointed as the temporary administrator, and I will go with $1,000 bond.
Thank you, Judge.
Thank you, Your Honor. And thank you for allowing us to participate remotely.
Yes, sir.